All right.
I say the only reason to shut off my email is to go look into them. Negotiation goes all the way to May.
Yeah. So then, so just to give the timeline, my email is
It's shut
shut
on
off
April 1st.
April 1st,
Mm-hmm.
and then here we go. Um, and this is signed May 12th.
Okay. Goes all the way to May 12th, where we sign. What do you guys sign?
Called Final Clean Break.
We sign
Solar Fire,
a
Eric
final
Wizens.
clean break. Okay.
So then there's a few other events that are there's like so there's a few other events that are relevant. First, the starting a custody case against me and summoning.
In between.
There's a custody case filed against me, and I'm summoned to a judge mediation.
A custody case has been filed at me, and
I'm summoned to a custody case mediation, judge mediation.
Judge mediation.
So that's one thing that's just highly stressful. And then the court 3 days before, the court rejects the Ava offering that I use her interpreter because Ava knows I has no money.
Reject that I use Ava's interpreter.
So I have to get a interpreter from Turku, short notice, costs like 900 euros.
No money. Okay, so.
Well, so then, so this is just more stress, sure. And then what is also clear, what becomes clear in this judge mediation, is that it's not a custody case. None of Ava's issues. The whole mediation was just the judge explaining that none of these issues are custody issues. Mm-hmm. So it becomes clear to me that Ava's attorney is manipulating Ava to harm me. Mm-hmm. Because obviously an attorney knows how the mental impact of this sort of process.
Clear to me that Ava is getting manipulated by her lawyer. Who is her lawyer?
I've discovered her name by accident just because I was trying to find a lawyer, and then but it doesn't matter. But anyway, she and the lawyer's never anyways, that's clearly manipulation. Then at the same time, the company.
Why I'm asking that to you is that isn't it weird that a lawyer who is not part of the story just wants to harm you? Like what?
Because I explain at one point I explain the conflicts of interest of everybody, the conflicts of interest of Vile. Because what's clear to me is no impartial professional attorney would recommend continuing this conflict, right? Any professional, impartial person like
I'm talking about Ava's lawyer.
Yeah. But Ava's lawyer got Ava to extort me again, threatening me with harm over the board minute wording.
This is the same.
And I then explained it in email, and all my emails and chats and so on go to lawyers.
Yeah.
At one point, Ava says there's 4 lawyers going through all of my chats, all of my emails and so on, trying to get me on stuff. And they try to do it. There's one part of the chats where they're trying to convince me.
How does she pay for that many lawyers? How does the company pay for that many?
Yeah, it's super expensive. So any honest
expensive.
Yeah, so for me throughout this process,
there is a huge amount of resource that are used to destroy me
and avoid any mediation. I'll cut the.
So there's a huge apparently there is a huge amount of resources that are used to destroy me and avoid what?
Avoid any mediation.
Mediation.
Like for me, like all through this stage, from the beginning of the conflict, for me everything is easily resolved through mediation.
Sure.
Because I have some good points. They have some good points. Through this phase, I don't want 51% of the company.
Yeah.
Like there's only they can run the company,
Sure.
right? I can help, but I can't run the company myself, right? So
I mean, you were CEO, so you did.
yeah, and then no, like at that time, there's nobody else to do Lauren's work in Africa. Like now, it can be done without them.
Yeah.
But at that time, there was nobody available to do what they did. We had the cash crisis.
Yeah.
So for me, like we have the cash crisis. We run out of cash. We have all these problems, legal problems. There's the registered share issue.
Yeah.
So for me, any professional coming into the situation,
look at everything and just like be like, okay, this is like this is like this, is like that. Okay, now you're good.
Yeah, no. So for me, it's inconceivable that any legal professional acting in the interest of Eva or Lauren, and much less the company, would recommend more conflict. So I expect now, like they go to because the whole part where they blackmail me and everything, they don't go to any lawyer, right? Then I expect them to go to lawyers who are like, okay, this is not good for the company. Eric wrote the patent and ran the company and is useful and so on, right? Let's discuss. Right, and what's clear is Ava has it's not in Ava's interest to have this insane conflict with the father of her children.
Sure.
Right?
Sure.
And what am I offering? Resolve the share illegally. People get their shares finally in a legal way, maybe my shares, whatever, or new shares issued, but that can be solved legally. And I'm not trying to get more.
Yeah, sure.
Just things should be done legally.
Okay.
And that puts me in a negotiating position.
Sure.
So, and then what do I want? All I want is to be returned to the board to contribute and make sure these legal problems don't happen in the future.
Sure.
Right? And then, and hopefully people learn something. Sure. That when there starts to be legal problems, you take a pause.
Okay.
And
Okay.
Bonjour.
You can cut.
Yeah. So from my perspective, all that needs to happen for the situation to be resolved is like an actual professional say the obvious common sense things. Like first, that David's letter obviously is problematic, and the whole hiding legal briefs and opinions, that's problematic, right? The accusing me of all these crimes and stealing David's shares and all that, that's problematic, and that I'm just objectively useful for the company.
Sure.
And that and the registered share thing is the problem, right? And all that and the best thing for the company and everybody is just solve everything by agreeing I return to the board. So all legal issues are solved. And David leaving.
Sure, but in between, a custody case has been filed at me.
So it
becomes clear to me that Eva is getting manipulated by a lawyer to harm me, and apparently there's a huge amount of resources that are used to destroy me and avoid any mediation from the beginning. Yeah,
I'm told there's 4 lawyers. I'm told there's 4 attorneys.
I am told by who?
By Eva.
By Eva.
There's 4 attorneys going through all my messages and emails and for
4 lawyers going through
for like a year.
All my communications for a year.
Right. And
try to find dirt.
Yeah, basically. And they come up with they at some point they argue these things. Avis at some point in the chats they argue these things. Like they try to argue they try to like they go back and forth accepting that because if they kind of go back and forth. They sometimes they want to present David's accusations as like non-accusations because then it's not blackmail. But I tell them it's still blackmail. It's just stupid blackmail if the accusation wasn't legally true. So then they're like, okay, yeah, well, that's stupid to make accusations that aren't true. So sometimes they try to argue that they were serious problems, and therefore, and it's just common practice that I'd resign, right? That they'd ask me to resign. So they go back from this, and then I just say like things aren't perfect. Like we're hovering above bankruptcy. Right, and all of the problems are like to try to get me on the loans, and I say like, well, when we talk about the loans in every shareholders meeting, everybody knew I was issuing these loans. Shareholders have been signing. So anyway, they go through all of this. They try to get me on dirt. It doesn't work, right? But these, huge amount of resources, and the auditor as well. So 4 attorneys and an auditor, because David has his attorney. There's the company attorney, Vile.
Sure.
There's Ava's attorney. I guess probably Lauren has an attorney at this point.
But that doesn't work. Okay.
Yes. So that doesn't work. So they
now at that point you're not on the board anymore.
Yeah, no. So they're trying to then, but this negotiate. But I've called shareholders meetings.
Yeah.
And they're trying to negotiate a resolution.
Yeah.
But yeah, in the custody case.
Yeah.
It was clear to me. So, the custody case, it was clear to me that that Ava was being manipulated by her attorney because everything goes to the attorneys, and I explained the conflict of interest because Ava tells me the message is from her attorney. She's like, I'm here to deliver a message. I'm like, from who? She's like, from my attorney.
Okay.
Right? That's not a good place to be as an attorney.
No.
Right? So Ava's attorney should recuse herself. And then I explained the conflict of interest of now that it's clear Ville has been acting against me. I explained Ville's conflict of interest, right? That it's not even clear how he became the company attorney.
Sure.
That's not a good place to be as an attorney.
No.
So instead of these people recusing themselves, their plan is to destroy me. Yeah. And to do that, you need to manipulate Ava because even with the new share ownership structure that they invent, we still have a majority, Ava and I, and Ava doesn't have any interest to do things illegally because she owns her shares just as much as me.
Yeah.
Right? And Ava has zero interest as a mother to have this insane conflict.
Sure.
And we've known each other for at this point 14 years without this sort of madness being created.
Insane. Okay.
So we've had obviously we had merit, and we ran the company successfully.
Yep.
So we've had difficulties and arguments, but we've never been accusing each other of crimes and shit.
Sure.
So our relationship wasn't perfect, but it was not this insane. Never. Right? And we'd have arguments, we'd make up later, right? In marriage or business later. Things would get solved. We'd always be able to talk and have lunch and work things out.
So my interpretation is that when I did expose to all these lawyers how much conflicts of interest they were into, instead of recusing themselves,
they stay in to try to destroy me.
They stayed in and opted for the solution where they destroy me.
Yeah, and here are the two key. So this is the key. It's undated, but yeah, it's undated. But I have an email version, and I have a paperwork version.
Of what?
So this is their big threat. Okay. So if you want to see,
show me. Okay.
So maybe just
Magnuson.
So this is the company. This is Ville,
the
company attorney.
Okay, so Eric.
They do say copy sent to
copy sent to vicens@gmail.com. Eric Vicens action relating to solar fire. Solar has approached attorney Atlo Magnuson concerning your action related to the company. Magnuson is Ville?
Yeah.
At first, the company is extremely sorry that the situation has escalated to this point. On behalf of the company, I ever state the following. By signing the company's shareholder agreement, you are bound by the confidentiality clause as set out in the Section 10 of the agreement. It should also be noted that the Finnish Criminal Code and the Trade Secret Act prohibit the disclosure on abuse of a company's trade secret. So I'm a CEO and chairman of the board of the company. You are obliged not to disclose any company's confidential information. Okay?
Yeah.
That's true. Company's notification. Breach of the shareholder agreement. Based on on our information, you have approached company client as follows. Having contacted the company's client CPM Industry with numerous messages after your dismissal as CEO and chairman of the board. CPM? What is that?
So that's our company, our partner in France.
Okay.
And I tell because I can go like for me, I can just go public with David's blackmail letter. Mm-hmm, yeah. And this same Ville said that David's blackmail letter wasn't company business; it was directed at me personally.
Contacted the company's client CPM with.
This is true, and just say I sent her the message, and I say this will affect you as well.
It is clear that you have violated clause 11.2 of the shareholders, according to which each shareholder undertakes and covenant that during the restricted period she shall not, on his or own or for any other person's account, solicit the service or endeavor to entice away from the company a director, employee, consultant, customer, or supplier of the company. Okay.
So this part is so there's the NDA clause.
Mm-hmm.
Then there's another clause which is called the solicitation clause.
Yeah.
And if you like poaching employees, like creating a competing business and poaching employees, and the solicitation clause has a 60,000 euro minimum penalty.
Sure.
But I don't solicit her to do anything.
As of today, the company does not know if any other business partner or company stakeholder have been contacted. However, should you have contacted others as well, those contacts will be considered separate breaches. According to the owner shows, you have 30 days to remedy by presenting a written apology to the company partner and stakeholder. You have contacted. Copy of each written apology shall be sent to one member of the board at least. This letter serves as a written notice to you of said breach. We consider the company has legal ground to claim damage before the arbitration tribunal in accordance with shareholders' agreement. 60,000 for each breach can be claimed for liquidated damages.
And
In
they argue-
addition, the company shall claim full reimbursement of its legal costs. The company shall also evaluate the possibility to seek for further preliminary injunction. Wow, slender. According to the received information, there is reason to believe, since your dismissal, you could be responsible for documented insult against member of the board. Also, according to the received information, you have repeatedly issued statement questioning the integrity, fairness, and professionalism of the board. This is true.
I have made these questions.
Yes, you have asked that. It should be noted that the company shall consider all legal options to secure its interest. God, fuck it there. Mr. Vison's accusation against the board, blackmail. According to the receipt, you have made accusation of blackmailing against Mr. Brohal because of an email sent by Mr. Tuyon Martin. You have implicated the board of the company in said blackmail. We have reviewed the material to a limited extent and consider that under the circumstance, even cannot. We have reviewed the material to a limited extent.
Even better, extend.
Oh yeah, to a limited extent, and consider that under the circumstance, cannot because and such accusation is false and defamatory against the board. We have been informed that you have made accusation against the board related to your dismissal, mainly unfair treatment, no necessity to be dismissed in violation of privacy. All the events related to a renewal process of the company leading to this are documented. The board of company ensure that they have followed a fair process at each step and comply with shareholders' agreement and Finnish law. As per minute of the last EGM, Mr. William Cleaver is currently conducting his on the same matter and will present his conclusion when they are ready. No necessity to be dismissed immediately. Pursuant to the Finnish limited liability companies and shareholders agreements, you may be dismissed with immediate effect. The board has considered that immediate dismissal was needed, taking into account your neglect as a CEO and the need to secure the company. Violation of privacy. It should be noted that it's a normal practice to disable former employees' email account. The company is aware of the law and regulation concerning former employees' email account. You have been dismissed as CEO of the company in March. You were informed that your email account will be disabled. Also, you have been reminded of the matter of April 19 and your email was disabled on Thursday, April 1st. For the sake of clarity, it is stated that your email account remains disabled and your privacy will not be violated. Should you need to search for any open any email, a request may be addressed to the company to facilitate search and access. Email may be searched and opened under the okay.
But like
no, no.
Amazing, eh?
No, this is illegal. No.
Well, it depends. It depends what if you mean by company supervision in
Yeah,
accordance with the law or whatever.
Okay.
But it's
No, it's weird. This is
yes,
this part
it's
is
weird.
However, is in the interest of both to reach an agreement to avoid full-scale arbitration proceeding at further cost. The company board has read your last offer. Unfortunately, the company cannot accept the offer. However, the board is still willing to make its last offer to reach an agreement. The offer presented below is valid for 2 weeks as of the serving of this letter. Company's right after signature, the company's board will apologize in a public blog post for treating in a way he feels unfair. In this blog post, mostly focused on Mr. Positive contribution to company's quality and contribution will be acknowledged. The board and the shareholders agreed to not give any negative or misleading statement in public or to third party in relation to its matter. Otherwise, should Mr. Positive agree with this pursued offer, he can be reinstated immediately at his wish on the company's website as an advisor during the healing period. The company drops any claim, current and future, to legal action to the extent legally possible concerning known event up to the present. The board shall recommend shareholders to vote to discharge Mr. Vison of liability as the CEO and chairperson for his previous term based on current findings. The company commits to help find buyer for Mr. Vison's share, all share or partly amount of shares at his discretion and his valuation of 1 million set by him for this step. The company commits to find buyers. You want to stop recording?
We don't need to, but we can.
It's
What?
yeah. I mean,
Well, for me it doesn't matter, but we can stop.
okay. If it doesn't matter to you, it's in your email.
It's here.
Okay. To have found buyers, all shares are partly amount valuation set by him for his step, and the company commits to find buyer for a minimum of 10 shares being bought within 8 weeks of signing a clean break agreement, whichever comes later. Alternatively, if Mr. Vincent does not want to sell shares anymore, the company is ready to pay him the equivalent of 6 months of his salary over the next 6 months. The company is open to discuss working together again in the future after a healing period of 6 months. The healing period shall include a mediation process. Mr. Vincent gain access to the company's email account. Mr. Vincent get 15% margin of any sponsorship deal connected to the sauna signed by the end of 2021.
There's also
And Mr. Vincent's commitment agrees to not give any negative or misleading statement of the company, its people, and their partner in public or third party in relation to this matter. Otherwise, Mr. Vincent rectifies statements contact made that are in violation of shareholders' agreement. Mr. Vincent drops any claims, current and future, to legal action against the company and people associated with the company to the extent legally possible concerning known events up to the present. Mr. Vincent transferred the optical software, all needed documents, and all his archive related to the company within a month. Wow. Mr. Vincent is open to discuss working with the company again in the future.
Because they discovered the problem of firing the CEO
Yeah,
effectively
the
immediately. Then they started. After they hired me, they sent me a long list of things to do. I'm like, I don't work for you anymore.
The healing period shall include a mediation process and separate session with Mr. Vincent. The mediation is optional. Mr. Vincent commit to use corporate email infrastructure only to communicate with the board. We respectfully request your response to the above presented offer within 2 weeks of receiving the letter. Any contact related to this letter, request to address to William Cleaver, attorney at law, Will Salonen, partner, attorney law train on the bench, co-head and dispute.
Co-head of dispute resolution.
And dispute resolution. Okay, so this
and
was...
then just a minute, and there's a key thing here. Just a minute. There's also... And people associated with the company.
Mm-hmm.
So
legal action against company and people associated with
which
the company.
Which will include Ville.
Yeah.
So he's now negotiating for his own interest.
To the extent legally possible concerning known events up to the present.
So he's now negotiating for his own interest. Sure. And this wording comes back, because then we do negotiate a version of this deal 2 in addition to nego terms V1.
So this is deal 2.
This becomes like the basis of deal 2.
Okay.
And then which becomes the clean break.
Oh, right, okay.
Because then I reject this, as you may imagine.
Yeah, that's
also another point. Before this is sent, I called a shareholders meeting on all legal actions against me.
Yeah.
Right? But I used the word demand, which is literally what's in the law, that a shareholder with more than 10% can demand a shareholders meeting to deal with any specific issue.
Sure.
Right? One of the main things this is for is to deal with being attacked, right?
Yes.
Right? And then...
it's in the law, this?
Yeah.
Oh, nice.
In Finnish Companies Act,
Sure.
right? Ville, like Eva tells me that, then Ville tells me that they don't, and the auditor, because Eva doesn't want to break the law, so she gets everything checked by the auditor, KPMG, right? So super weird. They just mean they say they don't have to accept my shareholders meeting request.
Okay.
E.g. extraordinary shareholders meeting, because I used the word demand instead of request. But it's literally the word is demand in the law.
Okay.
So this is the level of like insanity.
Yeah, so the state.